All right, let's see if you can hear me. No, not yet. Hello, hello, hello. Can you hear me now? All right, this seems like it's a little bit better. How are you doing? John Crump here. And we are do I have sound now? No sound. What the fuck? Hello, hello. Hello, hello. Can you guys hear me now? Can you hear me now? Awesome. Okay. All right. Not really sure what's going on here. But there was a decision handed down back in August 27th of 2025, and that was a decision in the United States versus Peterson, which dealt with suppressors. A three-judge panel, Judge Elrod, Higginbottom, and Southwick, issued a ruling and found against Peterson. As of right now, the Fifth Circuit, that panel withdrew their withdrew their prior opinion, and they substituted a new one, and the new one is definitely not good because it basically says that the NFA is constitutional. We're going to go over this. It's an 18-page opinion. We're going to skip a lot of it, but Peterson was found to have a unregistered suppressor, which he argues that the NFA is unconstitutional. Therefore, any law that's repugnant to the Constitution does not have to be obeyed, according to Madison versus Mulberry. George Peterson is a good guy, um, and he might be seeing this, but we're with you, George. If you're watching this, we are definitely with you. Uh, Jennifer Elrod, who is the Chief Justice, and this is the Eastern District. This is on appeal from the Eastern District of Louisiana. She says, "We withdraw our prior opinion and substitute the following." So then it goes through how they rated him and found that they don't have that he had a suppressor without any type of markings or anything like that that wasn't registered. Um, and then he was convicted in the district court, and now he's arguing that the NFA suppressor registration requirement is unconstitutionally burdens his Second Amendment rights. It goes into what a suppressor is, which we all know what a suppressor is, the benefits of it, how it's used, how it's not really used for crimes or anything else like that. Uh, but one of the things that we really have to look at is this line right here. Assuming without deciding the Second Amendment protects oppressors, we affirm the district court's denial of Peterson's motion to dismiss because we agree that the government, that the NFAs shall issue licensing regime is presumably constitutional under the New York State Pistol Rifle Association versus Bruin. And Peterson's as applied challenge fails on this record. Furthermore, because the exclusionary rule prevents suppression of the suppressor discovered at Peterson's home. We also affirm the district court's denial of his motion to suppress. He tried to suppress the evidence that they found a suppressor, and yeah, and they said that that is not going to fly here. So let's just go down to here. We now turn, because the rest is just explaining what NFA is and stuff like that, which you all know. We now turn to Peterson's as applied challenge to the NFA suppressor registration requirement under the Second Amendment. Peterson contends that suppressors are arms protected by the Second Amendment and that the NFA is unconstitutional. The government agrees that the Second Amendment protects suppressors, but maintains that the NFA is constitutional under New York State Pistol Rifle Association versus Bruin. We review de novo a district court's denial of the motion to dismiss the indictment, including the underlying constitutional claims. Then it goes into what the Second Amendment says. So we're going to skip all this. In Bruin, the Supreme Court applied the foregoing approach when it considered the constitutionality of New York State's prohibition on possessing firearms without a license. To obtain a license to carry a pistol outside the home, New York law required applicants to show proper cause, meaning a demonstrated special need for self-defense. Wait, let me just silence my phone here, guys. Sorry. I don't want to be distinguishable from the general community. And then quoting, in practice, New York required evidence of a threat, attacks, or other extraordinary dangers to personal safety. The law vested licensing officers with the decision to issue the license and provided limited judicial review of officers' decisions. The court had little difficulty concluding that this regime impinged on the right to bear arms in public, meaning that the law challengers surpassed step one. According to the court, the court then proceeded to step two, where it asked whether New York's licensing scheme fits into the nation's tradition of firearms regulations. The court's detailed survey of the Anglo-American history of public carry revealed that the historical restrictions touched on the intent for which one could carry arms, the manner by which one could carry arms, or the exceptional circumstances under which one could not carry arms. Historical restrictions did not, however, require law-abiding Americans to demonstrate a special need to exercise the Second Amendment. As the court explained, it knew of no other constitutional right that an individual may only after demonstrating to the government officials some special need. It therefore concluded that the New York licensing scheme violated the Second Amendment as applicable to New York by the 14th Amendment. The 14th Amendment basically says that the Constitution applies to the states. Relevant here, the court in Bruin contrasted so-called may issue licensing regimes like New York's shall issue regime that required state authority to issue a license whenever the applicants satisfied certain threshold requirements. Because these shall issue license regimes did not require an applicant to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding, responsible citizens from exercising their Second Amendment right to public carry. Rather, shall issue regimes, which often require applicants to undergo background checks, pass firearm safety courses, are designed to ensure only those that bearing arms in the jurisdictions are in fact law-abiding, responsible citizens. Shall issue regimes do so by applying narrow, objective, and definite standards to guide licensing officials in their decision. Because shall issue regimes employ objective criteria as opposed to subjective criteria, The court noted that nothing in its analysis of the New York May issue law should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing schemes. Now, over half the states are constitutional carry. I just want to put that out there. Justice Kavanaugh addressed the constitutionality of shall issue regimes. This is what's known as footnote 9 in the Bruin decision. He also listed some administrative conditions that shall issue licensing regimes may impose, like fingerprinting, a background check, a mental health record check, and training in firearms handling and in the laws of use of force, among other possible requirements. Even so, the court cautioned that shall issue licensing laws are not necessarily impregnable. As it explains, shall issue regimes remain subject to as applied challenges where lengthy wait times and processing license applications or exorbitant fees denied ordinary citizens their right to public carry. Basically, why the DOJ is suing LA. Justice Kavanaugh expressed similar concerns in concurrence, stating that shall issue licensing schemes are constitutionally permissible, subject, of course, to an as applied challenge if the shall issuing regime does not operate at practice. After Bruin, we considered a challenge to a background check requirement and considered the following. What part of Bruin controls our evaluation of theft of a firearm regulation? Its imposition of an historical showing to be made by the government, or is its various assurances that it did not disturb commonplace regulations and shall issue regimes? We answered the latter. As explained in McCrory, the Supreme Court in Heller described conditions and qualifications on the commercial sale of arms as presumptively lawful, basically saying that you have to have the FFL is constitutional. Bruin did nothing to disturb that part of Heller, so we read Bruin to implement a presumption of the constitutionality for shall issue ancillary firearms regulations such as background checks preceding sales. And they go ahead and they quote Maryland shall issue verse Moore, which was taken on en banc by the Fourth Circuit and was dumb, but whatever. When we consider McCrory, the plaintiff's challenge to the National Instant Criminal Background Check System, NICS, under which federally licensed firearms dealers first acquire information from prospective firearms purchasers, then submit the information to NICS for a background check. After conducting background checks, NICS provided a federal dealer with one of three responses: proceed if the purchase would not take place. The basically, I'm gonna skip all this. You guys know how NICS works. So let's go down here. Turning to this case, we assume without deciding that suppressors constitute arms, because remember, originally they said that suppressors were not protected arms, which was absolutely bullshit, but whatever. Even so, the NFA suppressor licensing scheme is presumptively constitutional because it is a shall issue regime, as Peterson counsel conceded at oral argument. His briefing before the district court and this court does not otherwise contest the shall issue nature of the requirement. The NFA provides that the ATF will deny a firearms making application if the making and possession of the firearms would place the person making the firearm in violation of the law. Further, we have no reason to doubt on this record that the NFA's fingerprints, photographs, background check requirements are designed to ensure that only those bearing arms in the all abiding responsible citizens. Peterson failure to make any showing as to how the requirements place an unconstitutional burden on his Second Amendment rights alone is dispositive. It is not even clear he could claim that the requirement posed an unconstitutional burden as applied to him, given his explanation that he failed to register it because he forgot to do so. Finally, the NFA enforces its objective shall issue licensing requirements through prohibiting suppressors possession by unlicensed persons, as it did of several shall issue licensing regimes that Brown cited approvingly. Peterson merits does not address the applicability of the shall issue presumption. In fact, it does not cite Bruin at all. Peterson has instead argued both in this court and the district court that the NFA is unconstitutional under the two-step means in scrutiny that Bruin overruled almost 2 years before his appeal was lodged and more than 1 year before he filed for his motion to dismiss. Peterson mentions Bruin's shall issue presumption only once, post oral argument briefing, where he dismisses the presumption as dicta. But we reject that argument squarely in McQuarrie, a case that Peterson nowhere cites. So he just talks about McQuarrie there. Then he said, these challenge provisions are presumptively lawful. I know this is kind of sucks, but whatever. We now turn to whether the NFA has been put towards abusive ends and through exorbitant fees or lengthy wait time in processing license applications. All of the above. In such a challenge, we consider the fact that of the defendant's own case. Here, Peterson neither alleges that he applied for an NFA license to make a suppressor, nor asserts that he paid the $200 tax stamps, nor claims that the tax or application processing times discouraged him from submitting the application to the ATF. He explains he simply forgot to do the paperwork after he made a suppressor. The record is therefore devoid of any facts that the NFA has been put towards abusive ends as applied to him. In addition, the record does not reveal how long applicants must wait for the ATF to process their NFA application. Peterson cites nothing to support his claim that the current processing times for NFA licenses approvals can be upwards of 8 months. It was when he made his suppressor. Repressed on this failure to produce evidence on that claim at oral arguments. So acknowledged the lack of oral evidence and later offered to file a supplementary letter brief with the court containing the support for his claim. He has never done so, though it would have been prudent to do so given that the government at oral argument disputed the 8-month claim and asserted the current NFA processing times only runs a few days. It does only run a few days now, but back then it was 8 months to a year. We declined to resolve this factual dispute and decide only that Peterson's unsupported claim that applicants must wait 8 months on average before they obtain the suppressor is insufficient to overcome Bruin's presumption. In sum, Bruin's presumption of the constitutionality of shall issue licensing regimes applies to the NFA application process. Peterson cannot overcome that presumption because the record does not reveal that the NFA has effectively denied him his Second Amendment rights. Accordingly, district court did not err when it denied Peterson's motion to dismiss the indictment. In holding so, we do not foreclose on the possibility of another litigant may successfully challenge the NFA requirement. Here, in light of the parties' agreements that suppressors are arms for purpose of the Second Amendment, we decide only that Peterson has failed to develop any argument or record to show that the NFA is unconstitutional as applied to him. We need not and therefore do not go further. Next, Peterson challenges the motion to suppress the suppressor. Kind of funny there. The district court concluded that the good faith exception barred application of the exclusionary rule. On appeal, though, Peterson does not mention the good faith exception. He instead argues the affidavit in support of the subject of the warrant application failed to establish probable cause in violation of the Fourth Amendment. Even if this were true, it would not go towards establishing the good faith exception does not apply. Accordingly, Peterson has likely forfeited his good faith exception argument. But we need not to rest our conclusion on this basis because, as explained infra, we would affirm the district court's good faith exception decision even if Peterson's arguments were preserved. That is, irrespective of whether the underlying affidavit actually gave rise to probable cause, we conclude that it was reasonable for all officers to executing the warrant to rely on it. According to the exclusionary the rule does not serve to bar emission of the suppressor. The district court denied Peterson's motion to suppress. All right. Basically, that's it. That is a kick in the nuts. So, I do see that we have Kurt member for 45 months out there. Chana member here. Thank you, Kurt. But let's go ahead and talk about exactly what this means for the cases coming up. Uh, what the cases coming up is the ASA, Second Amendment Foundation, FPC's case. Then we got the Silencer Shop, GOA, Palmetto State Armory, FRAC case as well. They are not challenging it on the same grounds as this lawsuit was. They are challenging the NFA as a tax law because there's no more tax. The $0 tax, and a tax have to have a revenue generating purpose. And so I don't think that this case, the Peterson case here, is going to weigh too heavily on that case. I think this is totally ridiculous, and I think the NFA as a whole is unconstitutional, but I don't think this really hurts this case. What Peterson can do now is seek an en banc from the Fifth Circuit, which means a full bench will hear the case. You gotta remember, this was a panel of 3 judges. This wasn't the full Fifth Circuit bench. So the fight in this case is not over by far. And no matter what the en banc says, if it goes to en banc, 'cause that doesn't have to be granted. It can always go to the Supreme Court, and the Supreme Court can decide whether to take it or not. So this is far from over. George, I guarantee you, knowing George, he's going to continue to fight this. His lawyer is going to continue to fight this because it's crazy. All right, guys. Okay. Oh, I got a question here. In your opinion, do you think Scottish would take Duncan versus Bonta out of the night, especially since last week they pushed it? Uh, I still think it's going to be the Illinois case, to tell you the truth. I mean, they could take Duncan versus Bonta, but I still believe it's going to be the Illinois case. But we'll have to see. They haven't denied it, and they haven't taken it yet, so we're just going to have to see exactly what happens with it. But they are. I I have no idea what that was doing, but they are a uh, they are going to take a um They are gonna take a assault weapons magazine case probably soon, and we're just gonna have to see exactly what case that is. I think it's gonna be the Illinois case, but hey, I could be wrong. It could be Duncan versus Sponta. Anyone that tells you they know exactly what the Supreme Court is going to say is full of it, because no one really knows unless you're a law clerk and you get a copy of a a opinion before it's released, like what happened in Dobbs. But that usually doesn't happen. That's very rare that that happens. All right, guys, there you go. Um, remember, vote for me for the Gundies. The Gundies, the Gundies, the Gundies. Vote for me for the Gundies. And also, Matt Hoover, CRS Firearms, is looking for help on getting his kid some stuff for Christmas because, yeah, it's hard. He's in a halfway house, uh, and stuff like that. I want to get more information, but I talked to him now, so that's good. I'm gonna go ahead and link his wish list in the chat here. So if you want to get it, get something for him, there you go. I'll throw it in the Discord as well. I also have a Discord. Let me go ahead and link that too. One second here. I think it's let me see here. Give me one second, guys. I think it's crumpy.com/Discord will bring you to the Discord channel. I just want to make sure it's not. Nope, that does not work. All right, there's a Discord channel in the description. Um, so or if somebody out there would list the Discord channel, that would be freaking fantastic. I don't have it on this computer. I'll put it in the description either way. All right, guys, that's it. I hope you guys have a great day. And with that, I am out of here. I will see you guys later. Yeah, we went from slow to busy, so that happened.